High FM, 101.9 megahertz of life.
And it is the time of the week that we talk about property. This is Transfer Talk here on High FM. And of course, we're joined by Taryn Harris, partner, co-founder of Harris Marcus Mahlangu Attorneys. Good morning and welcome back.
Morning, Howard. How are you?
I am good.
Great.
I was telling you off air that I'm getting so many questions, different aspects of transfer issues and challenges that I think we might have to have one of these sessions just dealing with people's challenges because it's really so interesting to see what people are dealing with.
There are so many, and every transaction, although most people seem quite simple, there are so many different things that you don't think of that can hold up a deal, delay a deal, stop a deal. And so that's why these are so important, just to get the knowledge out there.
Absolutely right. So keep an eye on that because we will let you know when that is going to be, whenever we can arrange that, and you can send us your questions that you are already doing. We can try and consolidate them. Today, we want to talk about what happens when a homeowner passes away, because we might assume that certain things are automatic, but maybe the house is owned by two parties and the one party passes away. What happens is in terms of a will, if there is a will, if there isn't a will, a valid will, etc. How complicated is this area?
So estate transfers are obviously more complicated than when you have living people for a variety of reasons. And it's also quite traumatic. Somebody dies and suddenly you're looking at a whole host of things. And generally, property in the estate is not something you think about immediately unless you have to. So what is an estate transfer? As you rightly said, an estate transfer is when you have a deceased person who had owned a property, and now they have property in their estate, and that property needs to be transferred out of the deceased estate, either to an heir or to a buyer. So there's different circumstances that you deal with as a conveyancer depending on what the circumstances are of the deceased person. Did they die intestate, which means they died without a will, which is obviously not ideal. Because then you're governed by the Intestate Succession Act in this country. Or you died with a valid will. If the will is deemed to be invalid, then that's another session. But essentially, if you die with an invalid will, then you die according to Intestate Succession Act.
Makes sense.
Okay? So who decides that that the property should be transferred? It'll either be determined, as I said, by what the wishes were of the deceased in the will, or how the Intestate Succession Act deems the property and the inheritance to be devolved down into the different heirs. So, first of all, the Master of the High Court has to appoint an executor for every single deceased estate. And most people don't realize that. They think, well, I'm a beneficiary, or I'm the only heir, or we didn't have children, I'm the spouse, I know he left it to me, I will just sell it. And you can't do that. So the first thing that has to happen is the master needs to appoint an executor and issue a letter of executorship if the estate is valued at more than 250,000, or a letter of authority if the estate is under 250,000. Only when you have that letter as the executor can you actually properly deal with the estate. So I've actually seen in the past, and it happens often with estate agents, that mandates are signed, for example, by the heirs or by a spouse.
But they're actually not authorized.
And it's not to say you can't do it, but there's going to be a problem down the line if there's an argument about commission and who actually sold it because they didn't have the authority to actually sign the mandate in the first place. So look, it's different if if the property is jointly owned, either because you're married in commune of property or you bought the property with someone else. Then it's different, and you can get away with signing a mandate, at least to some extent. But when it's solely owned by the deceased, and now it falls part of their estate, you can't actually deal with the property until there's an executor who's been nominated by the master.
Is the when people draft a will, they appoint an executor often. Is it that person, but they need to be confirmed by the court, or how does that work?
So just a couple of points on what you've mentioned. It's not the court; it's the master. That's very important.
Cool.
And there's different areas. There's the Johannesburg master, there's the
Right.
Pretoria master. There's different areas, obviously, depending on where the person died and where you lodge to become an executor. But interestingly enough, the person who gets nominated in the will is the executor. It can be this person or their nominee, or it can be one of two people. Now, it's generally not that actual person who will apply to the master and do everything else. They normally contact, like us, like an attorney, like a firm of attorneys, or they'll go to an accountant or someone else to actually assist them in actually the day-to-day of the winding out.
They might not have the experience.
Correct.
Right.
So most people are quite overwhelmed that if they get
Yes.
nominated as an executor, it means they do everything. So they don't. They sign a power of attorney, and they get someone to assist them on their behalf.
Right. Okay. So let's just break this down. What happens? Somebody dies with a will.
Okay. Somebody dies with a will, you go to the master, first of all, as the executor, you get the executor appointed, you get a letter of executorship. Now that person can act. First, what the point of the executor is obviously to pay out any liabilities against the estate and to distribute the assets. So now the property forms part of the estate. You have to look at whether or not that property has to go to the heirs, and that's what they want to do with it. And then you're doing an estate transfer where it's not actually being sold, it's being transferred to one or more heirs.
Okay.
So there's a whole realm of issues we can look at here. If the heirs themselves decide that, let's say, two of the children are living overseas and they don't want the property, then a redistribution agreement has to be signed. So there's different elements that a conveyancer will deal with to transfer that property. But let's assume now it's being left to one or two children in equal shares, and that property is now being transferred. So you need a liquidation and distribution account. All of these sorts of elements need to be done in order to transfer the property to an heir. When you're selling it to a third party, if that's the wishes, so either to my children or they can sell the property, or the heirs choose to sell the property, you then obviously would go through the normal course of getting an estate agent or listing the property. But people need to know when you're dealing with a deceased estate transfer, the timelines are different. It takes a much longer period of time depending on where you are or where the executor is in wrapping up the estate. An important point is when you sell to a third party, not only does the seller have to sign the power of attorney, but it needs to be sent to the master's office. They need to endorse that power of attorney to make sure that you're acting in terms of the will, or all the normal elements are complied with in order to sell the property to a third party. So it does take longer.
Because in fact they can't receive transfer until that estate is wound up.
Correct. So that has to be, it doesn't have to be completely wound up, but it has to get to the point that they can sell, they can distribute it.
That they can distribute, they can alienate this property.
Correct.
Right, and that might have an impact. And if somebody passes away without a will.
Okay, I just want to make an important point. It's important to look at transfer duty. If you are a surviving spouse, whether you're married in commune of property or out of commune of property, there is no transfer duty if you take that property, if it's being willed to you. So that's an important point.
Right, that is important.
Just want to make a note of that. Okay, intestate succession. Right. Please, if you don't have a will, I'm going to do my duty now. Please go get a will.
Yes.
Wills cannot just be signed on a napkin in front of one person. There are requirements in South Africa for a will to be considered to be a valid will. You need to have two witnesses. The witnesses need to be over a certain age. I believe it's 13, but I could stand to be corrected. It could be 14, but I think it's 13. And those witnesses need to sign at the bottom of the page where the writing ends, together with the person who is devolving the estate, who's signing the will, on every single page, dated, signed correctly. The witnesses cannot be beneficiaries or heirs. So there are very strict requirements when you are signing a will. So just make sure you have a valid will. and it's up to date with what you want.
Yeah. And I think that's a big thing, is that it's up to date. I know that so many of us are negligent in that. We draft a will, but life goes on and people change and circumstances change. And
Howard, you're not alone. I mean,
yeah,
all attorneys are in the same position.
Really?
I mean, I woke up after a few years of being in practice realizing I didn't have a will. So it's just
amazing
life takes
that.
over.
It does.
So
It does.
It's not. You mustn't feel shame if you don't have a will. Just
yeah,
go get
just
it done.
do it. Absolutely.
Right. So if you die without a will, so there's very interesting the Intestate Succession Act provides for how your assets are to be devolved after you die. So first you need to look at, were you married? Did you have children? And it's interesting, the way they look at it is, assuming you have more than 250,000 rand, if it's less than 250,000 rand to give out, the spouse automatically takes that share. But if it's more than 250,000 rand, you look at the children and you divide the estate by the amount of children you have plus one, which would be the surviving spouse. If the surviving spouse would receive less than 250,000, which is called the child share, then they get the 250,000 or the greater. If they would receive more by splitting up the estate, then that's the amount that they receive.
Right.
So they will receive that amount,
Yes.
and then it goes down to the children. And if a child has died, God forbid, then it goes to their children. If there are no children, it goes up. So
right, back to,
so it,
right,
it's
and
got
gets
a very
divided amongst those siblings.
correct, and you have to prove all of these things. So it's obviously much easier to pass
Have a
away
will.
with a will.
Just a quick question here from a listener. Does Taryn draft wills?
I do.
Okay, so
I'm a
there we
notary.
go.
I am a notary
Okay,
and a
so you
conveyancer.
got it. Okay.
I do draft wills. I can assist with that. But it's very these elements of property. There's so many aspects of personal life that you need to think about before you even pass away, on how you're going to let your property go and who you're going to give it to, and then make arrangements for, are you going to dictate that your children can sell it? Must it go to them first? Who does it go to?
Absolutely incredible. Carol Z says, this property information is golden guide for us at no cost. How's that?
It's my pleasure.
And Gail says, good morning, Howard. A teensy weensy bit of a problem. Before the executor can do their work, is that the master's office has to actually be working and open. Is that a problem?
Yes, unless you have good connections. We have great connections in the master's office.
You see, it's not what you know. Well, it's also what you know, but it's actually who you know.
But they are right. The master's office is not running as efficiently as we would like, and there's been in the newspapers for the last, many years, but especially over the last year, there's been lots of articles on how it's a mess, and they lose original wills and files go missing. It is a problem. But you just have to stay with the process and hope you have the right person in your corner to help you.
And that's why we're talking to the right people. What needs to happen for transfer to actually take place in a case like this?
So look, I mean, I don't want to go into the technicalities of a 42.1 certificate and a 42.2 certificate, but essentially if you are transferring to an heir, the liquidation and distribution account needs to be attended to. You don't need a master's endorsement. If you're selling to a third party, that doesn't need to be done, but you do need a master's endorsement. And there's a lot of other documents that the conveyancer would need to submit and would guide the parties through the process. But what is important to note, where a normal transfer, which I was discussing with you outside, can take 6 to 8 weeks, an estate transfer can take up to 6 months because it depends where you are in the process. It might take 4 months.
Yes.
But if, someone dies and they want to sell the property, and now suddenly they've got a buyer, but there's no letters of executorship done. It can really delay the process. So depending on where the estate is and being wrapped up, can guide you on how long it's going to take. So, I mean, we've had deals fall apart. Well, not me personally, but I know in the industry, deals fall apart when buyers and sellers are given unrealistic expectations, and the buyers can't wait. They need the property, they want to move in, and they didn't know it was going to take 6 to 8 months or whatever it's taking.
I definitely want to spend time, not this session, but another one, talking about the timing, because I do think that we're all optimistic. No, it won't take long and we'll get that sorted. But actually, they're real factors, and it has real implications.
Howard, next week I will take everyone through from
That is
beginning to
brilliant.
end
That is
transfer
awesome.
process, the
Great.
timelines that things normally take, so people have an idea of it's not something that you do every week
No,
or
of
every
course,
month or every
yeah.
year. So you forget or things change, but I will do that next week.
Okay, brilliant. Before we wrap, anything or the most important thing people need to know about property in the event of death?
So it can also happen, Howard, obviously, in the process someone can die. So most importantly, what people need to do, make sure they have a will, make sure it's a valid will, and make sure when someone dies that you go and get the letters of executorship or letter of authority as soon as possible. Then you can put the property on the market and you can do a lot of other things. So that's probably your first bet, the most important.
Absolutely. That is unfortunately where we do need to leave it. But the good news is we're going to continue these conversations. We'll continue this next week. That's Transfer Talk. Taryn Harris, partner and co-founder of Harris Marcus Mahlangu Attorneys.